Namaskar, brothers and sisters, ladies and gentlemen, students and scholars, teachers and trainers, professors, professionals, officers, officials, listener learners, respected doctors and directors, honorable ministers and managers, honorable advocates, supervisors, administrators and advisors, the most honorable President Professor Modi ji, I heartily cordially welcome. It is really nice time, nice place, nice session today that we are appreciating our holy Indian culture and education. Indian people are known by its culture, civilization, education, sports, and its traditional, conventional values that are given by our past is really recordable, historical, spiritual throughout the world. It's all historical, spiritual places have a great value in the form of heritage. Indian heritage, Indian past, Indian history, Indian culture is really a matter of great but greatest proud for the worldly people because whenever, anywhere, natural calamities are faced, then our Indians are not only the problem solvers but becomes the helper and healer to the worldly people. Words fall short in praise of such social humanitarian works. History is evident that whenever natural problems, natural devastations, calamities, disasters are occurred, then Indians become the great lesson solver, question solvers, and proves themselves as a great social, spiritual warriors. So in this time, natural changes we see around us everywhere in the form of spiritual, social, cultural, educational, and individually, personal, professional, intellectual, emotional, and spiritual. So at the different angles, in the different areas, fields, India is facing, not only facing, but inventing and innovating different technologies by the scientific advancements. What kind of changes today we have in our environment, atmosphere? It is really recordable and historical. Nature nurtures us like a mother. Nature teaches us like a teacher. Nature treats us like a doctor. Nature plays universal. Nature plays multidimensional, multi-sided, multifaceted role in our life. It is said in all kind of literature of the language that nature never defeat, never cheat, never deceive, never betray. In this materialistic world, we see around us different selfish kind of people because this world is known by materialistic world, substantial world. So our forefathers, freedom fighters, free thinkers, scientists, doctors, innovators, inventors, all started to message the oneness, equality, unity in the world. What is federalism? What is procedure of creation of new states in federal system? The union and federation both are similar ideographic. Each country is either union of states or federation of the states. If we see minutely, then with the equality, there is gross difference in the both. States are included with the center in both the systems of union and federation. The difference is only that In the federation, the states are included in the center with an agreement, and the states may segregate from the center anytime with their own will. The federation is a temporary arrangement where the union is permanent. In the federation, the center is weak and the states are powerful, whereas the center is powerful in comparison to the states in the union. After all, each country is either a union or a federation. All these depend upon the political and administrative conditions of that country. When India became an independent nation, then there was a question with it that which one is to be elected, union or federation? Our constitution makers elected the union. Between the union and federation, it has been stated in Article 1 of the Constitution that India, that is Bharat, shall be a union of states. It was stated by Dr. Bhimrao Ambedkar in view of construction. Our constitution could be a federation, but due to certain determined aims, it was called by the union. It has been stated by Dr. P.K. to the extent that the India was going to become federation but remained as union. Why India is a union in place of federation? As we have seen about that, India is a union and not a federation. There are two main reasons behind this. Unionism of India. The unionism of India is not as a result of mutual agreement amongst the units alike to unionism of America, and the states cannot segregate themselves from the center by their own desire. In the case of Upendra versus State of Assam, AIR 2013 SC 235, the Supreme Court had expected from the states to act with rectitude. India is a union of states. India is a union of states. It has been expressed in Article 1 of the Constitution as a union of states. Three kinds of state territories can be included in it. One is the territories of the states, two is the union territories specified in the first schedule, and three, such other territories as may be acquired. The following state territories are included in Union of India: Andhra Pradesh, Arunachal Pradesh, Assam, Bihar, Kerala, Madhya Pradesh, Maharashtra, Manipur, Meghalaya, Mizoram, Nagaland, Odisha, Punjab, Rajasthan, Sikkim, Tamil Nadu, Tripura, Uttar Pradesh, West Bengal, Chhattisgarh, Uttarakhand, Jharkhand, Telangana. Note 1. Previously, the name of Uttarakhand has Uttaranchal. It is re-nomenclatured as Uttarakhand by the amendment of year 2006. Note 2. From 2nd June 2014, the state of Andhra Pradesh has been divided into Telangana and Andhra Pradesh. Union territories. One is Delhi National Capital Territory. Two is Andaman and Nicobar Islands. Three is Chandigarh. Four is Dadra and Nagar Haveli. Five is Daman and Diu. Six is Lakshadweep. Seven is Puducherry. The administrative chief of the states is the governor, whereas the administration of union territories is under the president or the administrator appointed by him. Formation of new states. It has been stated in Article 2 of the Constitution that Parliament in the Union may, by law, one is admit new states or two is establish new states. Provisions for creation of new states are made in Article 3 of the Constitution. According to it, Parliament may by law form a new state by separation of territory from any state or by uniting two or more states or parts of states or by uniting any territory to a part of any state to increase the area of any state. 3. Diminish the area of any state. 4 is alter the boundaries of any state. 5 is alter the name of any state. Here it is to mention that the consent of states are not necessary for creation of new states. Change in the boundary or area of the existing state. The Parliament, by making law, can do all these works. A Srinath Reddy versus Union of India AIR 2009, NOC 1505 Andhra Pradesh. In the past years, new states were formed like Chhattisgarh, Uttarakhand, Jharkhand, etc. Then the name of Uttaranchal was changed to Uttarakhand. for Jharkhand inserted by the Bihar Recognition Act 2000. Uttarakhand substitutes for Uttaranchal by Act number 22 of the year 2006. Chhattisgarh inserted by the Madhya Pradesh Recognition Act 2000. Etc. acts are passed by the Parliament. There are so many reasons behind creation of new states. Change in the boundary or area of the existing state, or the change of their names as language, culture, geographical situation, etc. Process, creation of new states, change in the boundary or area of the existing state, or the change of their names can be done by passing the law by the parliament. It has its own process as such bill may be produced in either house of the parliament on the recommendation of the president. The president will send such bill to the state legislature to seek their views, and the bill will be returned by the state legislature with its comments in the scheduled period. State legislature can advise on the bill, but the parliament is not bound to accept it. Babulal Krate versus the State of Mumbai AIR 1960 SC 51. Any law referred to in Article 2 or Article 3 shall contain such provisions for the amendment of the first schedule and the fourth schedule as may be necessary to give effect to the provisions of the law. Member states and union territories are mentioned in the first schedule, and number of members of Rajya Sabha has been allotted to the states in the fourth schedule, so it is natural. Whenever creation of new states, change in the boundary or area of the existing state, or the change of their name is done, then it will affect the first schedule and fourth schedule. Under Article 4 of the Constitution, the Parliament has also been authorized to add. One is supplemental, two is incidental, and three is consequential provisions. Bangal Singh versus Union of India AIR 1960 SC 954. In the case of Mulla Periyar Environmental Protection Forms versus Union of India AIR 2006 SC 1428, it has been held by the Supreme Court that while creating new states by recognition, the Parliament has powers to make provisions under Article 3 and 4 to distribute the property, to determine the liabilities, and to divide land, water, and other resources. Border disputes. Here, a question is aroused that whether the law framed by the Parliament is necessary for implementation of an agreement executed for handling over a border dispute to a tribunal. While answering this question in the case of Megan Bhai versus Union of India AIR 1969 SC 78, it has been stated by the Supreme Court that there is necessity of neither any law for enforcement of executed agreement for referring the boundary disputes to a tribunal, and nor the necessity of a constitutional amendment. The government can take action for enforcement under its executive powers. In the case of Megan Bhai, enforcement of the agreement executed for referring to a tribunal, the dispute regarding the adjustment of inventory lied in run of touch between India and Pakistan was involved, The government was interested to do it without an amendment in the law. Assignment of Indian states area. By making law, the parliament can increase the area of an state, diminish the area of an state, alter the boundaries of an state, finish a whole state. But the question is this, that does the parliament's power to diminish the area of an state includes also the power to cede Indian territory to a foreign state? The case of in re-Barbary Union and exchange of enclave. AIR 1960 SC 845 is an exclusive example in this regard. In this case, the Indo-Pakistan Agreement entered into in the area 1958 for resolving a border dispute involving the transfer of one half of the area of Berubari Union by India to Pakistan for the exchange of Kuch, Bihar and Clay. When the central government intended to implement the above agreement, then there started a public movement in the Pakistan under Article 143 of the Constitution. A presidential reference was made to the Supreme Court of India. It has been stated by the Supreme Court that Berubari Agreement is such an agreement which has been executed to surrender the Indian area to a foreign state. The Parliament had no power under Article 3 to make a law to implement the Berubari Agreement. The shared agreement can only be implemented by an amendment of the Constitution as per Article 368. New challenges. The tendency of creation of new states, changing the name, etc., has increased after the independence. Linguistic, regionalism, and census have motivated for creation of new states and changing the name. As per demand of the persons of Tamil language, the name of Madras was changed to Tamil Nadu. The sense of regionalism gave birth to new states like Uttarakhand, Jharkhand, Chhattisgarh. The tendency of linguists, regionalism, etc. is becoming challenge in reference to creation of new states and change of name. Creation of new states on the basis of language and region may put the duty, unity, integrity and sovereignty of country in danger. Hence, the tendency of creation of new states, change in the name, etc., on the basis of language and region should be avoided. Characteristics of federalism. There are some its own specialties or characteristics of the federalism, and on the basis of those characteristics, it is being said that the federalism is adopted in India. The characteristics of federalism are mentioned in previous question. What is meant by sexual harassment of children under the Protection of Children from Sexual Offences Act 2012? Explain. What is sexual harassment? Explain with the help of major judgment. Among the various types of sexual offences described in the Protection of Children from Sexual Offence Act 2012, sexual harassment has been considered as a sexual offence of a simple nature. Section 11 of the Act provides for sexual harassment as a person is said to commit sexual harassment upon a child when such person with sexual intent utters any word or makes any sound or makes any gesture or exhibits any object or part of the body with the intention that such word or sound shall be heard, or such gesture or object or part of body shall be seen by the child, or makes a child exhibit his body or any part of his body so as it is seen by such person or any other person, or shows any object to a child in any form or media for pornographic purposes, or repeatedly or constantly follows or watches or contacts a child either directly or through electronic, digital or any other means, or threatens to use in any form of media a real or fabricated depiction through electronic, film or digital or any other mode of any part of the body of the child or the involvement of the child in a sexual act, or entices a child for pornographic purposes or gives gratification therefore. Let us explain. Any question which involves sexual intent shall be a question of fact. Embracing lady from behind and touching her breast with outrage of modesty. Paduran Sitaram Bhagwat versus State of Maharashtra AR 2005 SC 643. Hitting on the hip of a woman, Mrs. Rupan Deval Bajaj versus KPS Gill AIR 1996 SC 309. The lifting of the sari of the prosecutrix and open up pajama of himself. Venya Uraf Prem Prakash versus State of Rajasthan AIR 2009 SC 351. Punishment. It shall be punished with imprisonment of a year. Description for a term which may extend to 3 years and shall also be liable to fine. Section 12. Referring to the atrocities mentioned in subsection 1 and 2 of section 3 of the Scheduled Caste and Scheduled Tribes Prevention of Atrocities Act 1989, who can be the complainant and the accused under this act, whether prior inquiry is necessary for taking action under this act. Bentham was not only a social reformer but also a formulist of revolutionary changes in legal and judicial scope. Let us discuss this statement, analyze the effects of utilitarian theory of Bentham on law and justice. An important contribution of Bentham is assured in law, legislation, and judicial matters. Bentham was that first person who designed various plans for removing evils provided in various fields of public life on the basis of its own principle of utility. Bentham has propounded the principle of utilitarianism and reform affected since Bentham's day, which cannot be traced to his influence. It is clear that Jeremy Bentham may be said to be the father of reform in the law system. At the time of Bentham, the position of law in English was extremely intricate, complicated, and irregular. To improve this system, Bentham prepared many plans. These plans include practical and creative. According to Bentham, the main object of the law is security. The security is a necessity of social and happy life, whereas the independence is a kind of luxury which can be recognized by the law up to that extent where it is not against the security. According to Bentham's view, the legislation should take care of the following four aspects at the time of making law: livelihood, adequacy, equality, and security. The legislation should make lawmaking into consideration the interest of most of the people. Bentham had stated the following characteristics of best law. The law should be in simple, clear, and intelligible language. He was in, in irreconcilable of definitional technology, cabalistic, monotonous, limitation, customary, loosely composition, configuration. The law should be non the law should be in known of the general public. The law should be practical. The law should be according to exceptional expectation, requirement, and prudential of the general public. The law should not be contradictory. The law should completely be complicated. The law should completely be compiled so that to maintain peace and order in the society. Codification of the laws should be made. There, these reforms and suggestions of Bentham proved these reforms have to effect on the judicial proceedings. The suggestions of Bentham are clearly reflected in the existing judicial process. Judicial reforms. Bentham was also in favor of judicial reform along with the legal reforms. Bentham was very much perturbed and unhappy with this justice system of his time. He was very curious to see happiness of the weak and low clerks. For this purpose, he felt necessary to improve the justice system. The judicial system of England at the time of Bentham was very perverted and deferred. The justice was very costly. The judicial process was extremely intricate. There was no access of great person upset up to justice. A person was required to obtain services of the advocates for going to the court, and the fees of the advocates were too high. According to Bentham, the justice is sold out in this country, sold out at very high cost, and the person who is unable to pay the value does not get justice. There was no respect and belief for the judges in the mind of Bentham. He was calling the judges as judge and company. It was said by him that the judges are of the caste of no active and powerless who were tending to any matter even after their disrespect. They are mindless, hypothetical, stubborn, and lazy, and lose their morality for selfishness. Bentham has right in his script that what a, what a kind of irony that a judge being called impartial by putting a person in hardship for all the life then shake his all property. It is pretension of Emperor Johann that we will not keep any person deprived of justice and will not sell the justice. This pretension is of that Emperor John who is being called Wicked Johann. He, by depriving of 99% out of 100, for the justice, sells the justice to the 100%. He was also of the view that our laws are made by the judges for their own benefits. These were the reasons that Bentham was extremely perturbed with the existing judicial system, and he was in favor of the appointments of judges on the basis of higher education and ability. Bentham was against the jury system. It was in favor of the decision of a matter only by one judge. He highly protested for allowing fees to the judge instead of paying after. All the time, Bentham advocated for the fair and cheap judicial system. Bentham on and on was telling that each person should be his own advocate. He was in favor of informal action before the mediator in place of formal advocacy. He was of the view that mediators should make efforts for settlement between both parties. Bentham was desirous to increase the working capacity of the courts by simplifying the judicial process. He was of the view that due to informality, ambiguity, and too intricacy in the laws, there is delay in justice, expenditure increases, it motivates litigation, and general public is deprived of justice. This is the reason that Bentham stated that laws should be in simple, clear, and spontaneous language. In this way, Bentham struggled for improvement in judicial system and judicial process still life. Later on, the changes were made in the justice system according to ideology of Bentham, and the judicial process was made simple, cheaper, and speedy. Improvement in punishment system. Bentham was also too perturbed with the punishment system of his time. He has stated that the capital punishment is being given for the offences have no such gravity, and sometimes the persons doing severe offences have no penalty. This is the reason that Bentham presented many plans for improvement in punishment system as the punishment should be in proportion to the offence. Capital punishment for the offences having no such gravity is not gratification. Awarding capital punishment for theft of a person, for theft of a school is in adverse to the judicial principle. Care should be taken that an innocent person may not be penalized. It is principle of criminal law that whether 100 offenders may be saved, but an innocent may not be punished. But an innocent may not be penalized. The punishment should not be barbarous. The punishment should be given in good faith. The quality of punishment should be same for the same offences. Discrimination in relation to punishment is not fair. The punishment should be defined and unbiased. There should be coordination between the punishment and offense. That is, the punishment should be given according to the nature of offense. The aim of punishment should be reformative. The punishment should not be given with a sense of revenge. The punishment should be ideal. That is, it should be educative. The paid by the punishment up to that extent so that he may not repeat the offense. The form of punishment should be such as so that the offender become unable to do offense in future. A provision for compensation should be made in the punishment for the suffered party. The punishment system should be according to public interest and public opinion. The final aim of the punishment should be prevention of offences. The following aspects should be taken into consideration while determining the quantity of punishment: nature of offence, intention and circumstances of making offence, previous conduct of the offender, character of the offender, behavior of the offender, etc. In this way, Bentham makes suggestions for making entire changes in the punishment system. These suggestions affected to the prevailing judicial process. The judicial process has become simple, speedy, and justified. The suggestion of Bentham are clearly reflected in the existing judicial process. Prison Improvement Plan. The arrangement in prison at the time of Bentham was also extremely pitiful, as brutal and inhuman behavior was being given to the prisoners in the prison. They were kept in the dark cells. Food of low quality was given to them. Child, adult, and errant offenders were being kept in one cell, which had bad effects upon the child offender. The condition of prisoners was very pitiful. Most of the prisoners were in tattered condition. There were no schemes for reform of offenders in the prisons. For improvement in the above system, Bentham made various plans and stated that one is the system of secluded imprisonment should be derogated, because due to secluded imprisonment, the mentality of the offender become more deformed. Hard labor should not get from the prisoners in the prison. The prisoner becomes uninterested toward labor due to hard labor. Adequate arrangements of education for prisoners should be made in the prisons. Creative works should be taught in the prisons to the prisoners so that they may be self-supporting and may be an ideal citizen. Prisoners, prisons should be under humanity condition. Adequate program arrangements for accommodation, food, education, etc. should be made in them. The authorities of prisons should make efforts to improve the prisoners. Construction of the prison should be done in moon shape. The cells of the prisoners should be all around the prison, and the room of jailer should in center so that he may watch to all. This plan was nomenclatured as panopticon. In this way, Bentham gave a new direction for the judicial process through the legal, justifiable and penal and prison improvement plans. Jurisprudence is the science of first principle of civil law. Salmon explained in context of definition of jurisprudence, the name of Salmons cannot be ignored. Salmon had been contemporary jurist to Austin and Holland. Salmon had criticized the definition of jurisprudence both by Austin and Holland. Salmon criticized the definition of jurisprudence by Austin because Austin had propounded general jurisprudence and the definition by Holland was criticized because Holland had rejected specific jurisprudence. Salmon did make objections to the general jurisprudence of Austin but accepted the concept of specific jurisprudence. Salmon defined jurisprudence as jurisprudence is the science of the first principle of civil law. According to Salmon, in primary sense, such jurisdiction constitutes all legal principles. It is the knowledge of law. Therefore, it is also called the science of primary principle of civil law. The Salmon believed that law is implemented by the courts. There is provision of sentence on breach of law, and it is different from religious and moral rules or laws, and it is the reason that it is called as a branch of civil knowledge. Essential elements. The definition of jurisprudence shows three essential elements. Science of law. First is science of law, two is first principles, and three is civil law. Science of law means that the serial-wise study of basic principles of specific legal system. All legal principles are studied in an order under the science of law. Law means such a group of principles which have been recognized by the state and are implemented by the administration of justice. In simple words, it can be said that they are the principles recognized and implemented by the courts. First principle, it means the principles found in any specific legal system. The first basic or necessary principle of a specific legal system are studied under jurisprudence. In this, the residuary or assisting rules or principles are left out. These necessary or basic principles are such which separate the law, from other rules. The rules which regulate human conduct can be of three types. One is religious, two is moral, three is law of jurist. Salmon has only considered the law of jurist as the subject matter of jurisprudence because it is recognized and enforced by the courts. There is sentence on their breach and are implemented by a definite authority. Civil rule, civil law. Civil law means the law of a country or of international. Civil law is used for municipal law or citizen law, and as object is to separate it from international law. The jurisprudence is used under civil law in three forms. One is explanatory, two is legal history, and three is science of legislation. Under explanatory method, the elements of actual law found in past or present are analyzed. Under legal history, the procedure of historical development of any legal system is analyzed. The purpose of science of legislation is to determine how should be the law. Salmon had explained the difference between two classes of jurisprudence, general and specific. General prudence mentions the complete group of legal principles, whereas specific jurisprudence mentions a particular part of those principles. Specific jurisprudence is also called by the name of principal jurisprudence. Salmon has classified it into three classes. One is analytical, two is historical, and three is ethical. The purpose of analytical jurisprudence is to analyze the basic principle of law without considering the historical orography or development or its ethical importance or legality. The purpose of historical jurisprudence is to analyze the general principle related to origin of law and its development. The purpose of ethical jurisprudence is to study the ethical importance of law. For detailed study of jurisprudence, study of these three schools is essential. In its criticism, we can say the definition of jurisprudence by Salmon have been criticized by certain jurists. Allen said that Salmon had restricted the area of jurisprudence. The area of his jurisprudence is restricted to merely one legal system of England. Few critics had to say that, and few critics had to say that definition of Salmon consists of variable meaning words which cannot refuse the possibility of and hence entrance of unclear notion. Even with all this, Salmon has tried to give a good definition of jurisprudence. Let us explain in detail the internet banking services. What is internet banking service? Presently, almost all banking services have become computerized. This has increased the quality and promptness of work. A lot of time has also been saved. So the chances of mistakes have also reduced a lot. On the other hand, it has also suffered some damage. Cybercrimes have started happening. Bank fraud cases are increasing continuously. Overall, it can be said that computerized banking services or simply say that internet banking services have proved to be a boon in the commercial world. Then it was too. But despite all this, it would not be wrong to say that today almost all banking services have become dependent on computers and internet. What are internet banking services? Internet banking services include balance information, payment information, detail of transaction, online transfer of funds, card-to-card transfer, buying and selling of mutual funds, money order dispatch anytime, opening of fixed or recurring accounts, use of checkbook, withholding of payment requests, credit and card facility, monthly bank account by email, ATM facility, linking bank account with ATM debit card, premature closure of recurring deposit, demat account, credit details, update interest rate, online bill payment, online shopping, book a ticket, mobile recharge, deal in the stock market, conversion to EMI, online lending, consumer correspondence, internet banking performance, corporate internet banking, etc. Thus, the scope of internet banking services has increased considerably. Now, we will study some of the main internet banking services. One is phone banking services. Today, a lot of banking transactions have started happening through the phone, such as get information about the balance, request for fund transfer, withholding of check payment restriction, registering for mobile banking, getting information about current interest and exchange rates. Mobile banking services like phones, there has also been a lot of growth in mobile banking services and many transactions related to banking. Banks have started being done through mobile, such as get account balance information, credit card balance check, getting credit information, internet, mobile, purchase and redemption of mutual fund, etc. It is worth mentioning here that in the year 2013, there were 9.5 million mobile subscribers in India, which became 1 billion in the year 2016. Mobile services are continuously growing in India. In this direction, India comes second in the world after China. ATM services. ATM is an important service to withdraw money from the account. The ATM provides 24-hour service, money transfer from account, balance information, short account details, and PIN number, PIN change option. This saves time and troubleshoot. With regard to ATM services, rules are made by the Reserve Bank of India from time to time. Many important rules have been given in the ATM card rules 2014. A lot of changes have been made regarding ATM transactions by issuing a notification by the Reserve Bank of India soon after the demonetization order of November 8, 2016. Electronic fund transfer. Electronic funds transfer means transfer of funds in which any person directs, authorizes, or orders the bank to be transferred by electronic means, which includes place of sale, ATM transaction, direct deposit of funds, withdrawal, transfer by telephone, internet, card payment to debit or credit to his account. National Electronic Fund Transfer. National Electronic Fund Transfer is a nationwide fund transfer system in which funds can be transferred from one bank branch to any other bank. It works on the concept of a centralized ledger system in which remitting or receiving fund transfer operations are conducted from Mumbai. There are many separate branches all over the country. It is practiced by deferred net settlement in which the transaction is done in pieces and at a fixed time. Real-time gross settlement. Real-time gross settlement service is based on money transfer that take place from one bank to another on real-time gross basis. This is the fastest money transfer done through the bank. Real time means there is no waiting element in it. Gross settlement continues. Gross settlement means the transaction takes place on an aggregate basis without being linked to any other transaction. This mainly happens for large sums of money. Credit card payment system. Credit card payment system means a plastic card assigned to the holder which has a specified limit within which the holder can purchase goods or services or receive advances. Its practice has been going on in the country for a long time. The following are the parties to the credit card scheme. Card holder, authorized person to use credit card for purchases of goods and services. Card issuer. It means card issuing institution. Merchant entities that accept credit cards for goods or services. Merchant acquirer, banks or non-banking financial institutions that enter into agreements with merchants for processing credit and transactions. Credit and association. These are organizations that license card issuers need to use their own trademarks such as Visa card or MasterCard and that provide settlement services to card issuers and merchants. The Reserve Bank of India maintains a constant vigil on credit card security. In addition to online alerts, the payment system is secured through authentication and validity of the information in the card through an invisible system. What is professional Divines in journalism. What is the role of press council in preventing the professional deviance in journalism? Let us write note on press council. Journalism work is extremely risky. If it is said, it will not be an exaggeration that it is not a bed of flowers but a crown of thorns. Every person associated with journalism, be it reporter or editor or publisher or printer, has to be cautious and careful on the every step. Karnataka High Court said that in the matter of High Court of Karnataka versus State of Karnataka IR 1998, Karnataka 327, before compiling and publishing the news, it should be resolved whether they are correct, reliable, or authorized. If news is published without resolving it, the editor may be liable to punishment. In Singh and in Vijay Kumar Iyer 1997, SC 73 in the matter of A. Raju versus Srinivasan Iyer 2010, Madras 77, it was held by Madras High Court that media or press should publish news etc. with proper verification. It is for this reason that journalists have their own code of conduct. Every journalist is expected to follow this code of conduct. The main points of the code of conduct are as follows. One is the ideal of journalism should be goodwill and fairness. Journalists always introduce goodwill and fairness. Two is journalist does not suffer from bias. Three is in the publication of news, public interest should be given importance. The unity, integrity, and sovereignty of the country remain paramount. News that promotes violence, tension, rebellion, treason, etc. should not be published. Avoid fictitious and provocative news and comments. Privacy and dignity of the witness should be maintained. Journalists never fall into temptation. Each public confidence. The news should not be defamatory and insulting. No one should object to personal life in the news. Foreign and offensive news should not be given places. Journalists maintain secular nature of constitution. Social, human and moral values should be given priority in the publication of news. More and more material should be collected in newspapers for the upliftment of weaker sections of society. Government policies should try to reach the masses. The democratic values and ideals should be protected in the news. The life of journalists should be simple and steeped in human values. Have the ability and sensitivity to understand human suffering in journalists. Unreasonable competition should not be given place in journalism. Efforts should be made to eradicate social evils and superstitions through journalism. Press is the fourth effective pillar of democracy. It is the press that protects constitutional ideals, human values, and healthy democratic tradition. All this is possible only when everyone associated with journalism follows their code of conduct. In the matter of Vijay Kumar Singh, son of in the matter of Vijay Kumar Singh versus Union of India, AIR 2007, NOC 21-153 Madhya Pradesh, it was held by Madhya Pradesh High Court that the press also had its own code of conduct. He is governed in the same code of conduct. The rules of morality and good conduct also apply to him. They cannot be allowed to publish. They cannot be allowed to publish news in sensitive cases on the things heard. Press is the fourth pillar of democracy. It is a powerful medium for the expression of ideas. It is the press that transmits the thoughts of the human mind to the public. It would not be an exaggeration to say that the press acts as a link between the public and the administration. In Maneka Gandhi versus Union of India of 1978, SC 597 case, the Supreme Court has considered the press to be indispensable for the success of democracy. As per Article 19(1)(a) of the Constitution, every citizen of India has been given the fundamental rights to freedom of speech and expression. This is the authority on which a person's mental and intellectual development depends. Speech and expression is a powerful medium for the exchange of ideas. Though freedom of the press is not mentioned in freedom of speech and expression, but indirectly it is included in it because it is to the press that a person's ideas are conveyed to the masses. M. Hassan versus Government of Andhra Pradesh, AIR 1958, Andhra Pradesh 35. In the matter of Virendra versus State of Punjab, AIR 1958, SC 986, it was held by the Punjab and Haryana High Court that no separate freedom has been provided to the press under the Constitution. Freedom of the press lies in the freedom of speech and expression provided under the Article 19(1)(a) of the Constitution. In Re Haria Singh and in Re Vijay Kumar AIR 1997 SC 73, in these matters the Supreme Court has called freedom of the press the mother of all freedoms. It is necessary for mental and intellectual development of the person and for the all-round development of the society. Exploring the truth is not possible without the press. Freedom of speech and expression is provided under Article 19(1)(a) of the Constitution. Is the cornerstone of democracy. Similar views have been expressed in the case of Indian Express newspaper versus Union of India AIR 1986 SC 872. It was held by the Supreme Court that press is the fourth pillar of democracy. It pays the way for mental and intellectual development of a person. Overall, freedom of the press is an important part of speech and freedom of expression. The press itself nurtures freedom of speech and expression. The press embodies freedom of speech and expression through the propagation of ideas. Srinivasan Muse, State of Madras, year 1926, Madras 79. But freedom of the press is not free. It also has its limitation. Its form is non-violent. It's necessary. No person should suffer physical, mental distress from the press. His reputation should not be hurt. It is expected. Non-violence does not mean protecting the living things, but it also has to provide protection. But it also has to provide protection to the rights of the living things. If the press causes physical or mental trauma to a person or causes damage to his or her fame, then it is violence. A US report stresses the need for journalistic discipline. Maintaining discipline in the business of journalism is inevitable in harassing Ahmed in Vijay Kumar, year 1997 SC 73. The Supreme Court had clearly stated that the freedom of the press is not always free, unlimited and unrestricted. Giving unrestricted freedom to the press would mean giving him uncontrolled license. Doing so, doing so will create chaos and disorder in society. Overall, freedom of the press also has its limitation. Violation of this limit leads to offences such as defamation and contempt of court. Defining defamation in section 499 and 500 of the Indian Penal Code 1860 is considered a punishable offence. According to this, whoever by words either spoken or intended to be read, or by signs or by visual representation, makes or publishes any impulsion, any imputation concerning any person intending to harm or knowing or having reason to believe that such imputation will harm the reputation of such person is said, except in the cases hereinafter expected, to defame the person. It is responsibility of the press not to publish any such material about a person which will hurt his reputation or goodwill before publishing any news, comments, articles, pictures, etc. It should be resolved that it is true. In order to avoid the crime of defamation, it is the duty of the press that the material published by it, one, it should be true and fair, two, it should be bona fide, three, it should be careful. Work done with truth, harmony, and passion can save the press from the crime of defamation. It is for this reason that it is always expected from the press to check its truth and credibility before publishing any news. In Hari Vijay Singh, the editor of the Sunday Tribune and Punjab Kesari newspaper, had to apologize not only to the apology but also to the punishment due to the misinterpretation of the wrong news regarding the allocation of petrol pumps and gas agencies. In this matter, the Supreme Court held that it is the responsibility of the press that news published by it should be based on true events and facts. It is necessary to confirm their veracity and credibility before publishing the news? Is it necessary to make sure that any news is capable of being published or not? Because news creates public opinion in the matter of destruction of public and private property and state of Andhra Pradesh area 2009 SC 2066. It was held by the Supreme Court that the media's responsibility increases at the time of ban and agitation. At such times, at such times, special care should be taken to protect public and private property from loss in news communication. The same applies to contempt of court. The judiciary is an independent and impartial third body of government. It is necessary to keep its dignity intact. The act which hurts the dignity of the court is considered contempt of court. Supreme Court Bar Association versus Union of India, area 1958, SC 1985. It was held by the Supreme Court that the question of contempt of court is not a question of the dignity of any one judge, but the question of the dignity of the entire judiciary. It is the responsibility of the press to protect the dignity of the judge and the judiciary. In Articles 129 and 215 of the Constitution, the Supreme Court and High Court respectively have been declared as courts of the court. According to this, a person convicted for its contempt can be punished by the Supreme Court and the High Court. The punishment for contempt of court has been prescribed in the Contempt of Court Act 1971. There are two types of contempt mentioned in it, civil and criminal. Willfully disobeying any court decision, decree, order, writ, etc., or willfully disobeying the permission given to a court is civil contempt. In criminal contempt, the following tasks are performed orally or in writing. One is to tempt the court who is to adversely affect court proceedings with functions that interfere with the Adam inspiration, Adam administration of justice. The press should desist from such actions. It is the responsibility of the press not to unduly criticize any judge or court and do not do anything which will adversely affect or interfere with judicial proceedings. While clarifying the responsibility of the press by the Supreme Court in C.K. Daftari versus O.P. Gupta, area 1971, SC 1132 case, it has been said that it should properly publish the report of judicial work. Even if it criticizes judicial work, it should be proper and correct. Even if there is any complaint against judges, it is in good faith. Overall, the press is expected to act with truth, harmony, and passion regarding the publication of judicial proceedings. In order to avoid contempt of court, opinion has been expressed in Re-K.L. Gore. The AIR 1941 Lahore 105 is that the press should not do any act which hinders the administration of justice. Go to the bottom of the case and investigate the matter, and only news based on the right facts should be published. Breaking the facts and making blatant news can bring the press under the purview of defamation or contempt of court. In a conference of jurists held in Madrid, considering the code of conduct of the press, it was said that such news, articles, pictures, etc. should not be published by the press, which the innocence of the accused is affected, to his confidentiality of judicial proceedings is violated, investigations are adversely affected, Judiciary proceedings are affected. In the matter of M. Hassan versus Government of Andhra Pradesh, year 1998 SC 35, the Andhra Pradesh High Court had considered the responsibility of the press to keep the dignity of the court intact. The conclusion is that people and press related to journalism business should maintain their transparent nature. The press should not do any act which causes any kind of tribulation to any person, community, organization, or government body, etc. When the wrong stories related to the allocation of petrol pumps and gas were published in the Sunday Tribune and Punjab Kesari newspaper against the sons of Chief Justice A.S. Ahmadi of the Supreme Court of India, it was natural for the Chief Justice to suffer and harm. This is the reason that many responsibilities have been imposed on the press in this matter. Now it is expected from the Supreme Court and High Court that they should not name the victim of rape in their decisions related to rape. This had to be said. Now it is expected from the Supreme Court and High Court that they should not name the victim of rape in their decisions related to rape. This had to be said so that the woman suffering from rape would have a secure place in society. She should not be a victim of sarcasm and neglect in the society, and at the same time of self-aggression should not be borne to the woman suffering from rape. These are all issues related to the press. State of Punjab versus Ramdev Singh AIR 2004 Supreme Court 1290. The expectation is that media maintain its independence, impartiality, transparency, do not cause physical and mental trauma to any person, do not cause his fame to be abducted, do not publish the news in such a way that it can cause physical, mental or pain to any person. Press Council. Freedom of the press is indispensable for free and fair expression. Fearless journalism cannot be imagined in the absence of press freedom. It is the press on which democracy depends. The independent existence of press and journalism is considered essential for the survival of democracy. This is the reason that a Press Council Act was passed in the year 1948 to maintain the freedom of press and journalism and raise their standards and improve them. This act is applicable all over India. Composition of Council. Section 4 of the Act provides for the constitution of the Press Council, and in Section 5, its composition. The Press Council is considered a corporate body. It has been said in Section 4 that it will get perpetual succession. It shall have a common seal and can be sued on behalf of or against it. The council will have 29 members, including the chairman, that is the chairman, a chairman, and 28 members. Arrangements have been made to appoint the chairman by a committee in which the chairman of the Rajya Sabha, the speaker of the Lok Sabha, and a person elected by the members of the council. Other than the chairman, the member will be working journalists 13, newspaper owners 6, news agency administrators 1, individual with special knowledge in education, law, science, literature or culture 3, members of parliament 5. The tenure of members will be 3 years. Objects and functions of council. Section 13 of the Act highlights the purpose of the council and its function. One is maintaining freedom of the press, maintaining and improving the standard of newspapers and news agencies, helping newspapers and news agencies to maintain their independence, preparation of code of conduct for newspaper, news agencies, journalists, etc. Encourage a sense of responsibility and public service among journalists. Regularly publishing news in public interest and public importance. To consider from time to time the assistance received from newspapers and agencies from abroad, etc. General power of the press. The general powers of the council are mentioned in section 15 of the Act. The council has been given the following powers of the Code of Civil Procedure 1908 to discharge its functions: summoning and enforcing the attendance of any person and examining him or not, requiring discovery and production of any documents, receiving evidence on affidavits, requisitioning, requisitioning any public record or copies thereof from any court of office, issuing commission for the examination of witness or documents, levy of fees. Section 16 of the Act provides for the levy of fees in the matter of Singh versus State of Uttar Pradesh 1979 for CSCC 597. It was held that the word levy means to collect. Then the fee needs then the fee needs to be judged. Mehta Ispal Limited versus CMOAR 1981 Madhya Pradesh 621. Power of prosecution. Section 14 of the Act confirms powers of gratitude to the Press Council. In fact, it is a power through which the Council regulates the conduct of newspapers and journalists. According to the provisions provided in this section, the Council may perform if a newspaper or news agency violates the norms of journalism. Any editor or working journalist takes professional treatment, etc. In such cases, the council is given an opportunity to hear the problem concerned. This is in accordance with the principles of natural justice. A case of Ajay Goswami versus Union of India, year 2007, SC 19 SC 493 is quotable in this regard. It was held by the Supreme Court that freedom of the press is not absolute. It may not be given an open space to public obscene and indecent articles or material. No news is seen from just one point of view. It is interpreted by reading it completely. It is noteworthy that the members of the Press Council have been considered as public servants within the meaning of Section 24 of the Indian Penal Code 1890, Section 24. Similarly, for the proceedings in good faith taken by public servants under Section 23, they have been protected from any kind of statutory proceedings. Thus, this Act is an important to regulate the freedom of the press, the standard of the newspapers, and the conduct of journalism. It is the same act which prevents the press and journalism from deviating from the path. Press journalism is based on this act. What do you know mean by the police deviance? Let us discuss the nature and causes of police deviance in India for tomorrow. describe about the publication of legal magazines in India. Presidents has an important place in judicial administration. Presidents helps in making decisions, but it can say that the precedents guide the courts during taking decisions. According to Article 141 of Constitution, the law declared by Supreme Court is binding over all the courts of the states of India. Sumaram versus State of Rajasthan, AR 2006, SC 5250. Supreme Court's decisions are binding over all subordinate courts. Virendra Singh Yadav versus Rajkumari Yadav, AR 2006, NOC 897, Madhya Pradesh. It is required that it fulfills the conditions of radio rush ratio Desi Delhi. State of Maharashtra versus P. Jagannath AR 2007, Bombay 167. The decisions of Privy Council are also binding over High Courts, except they are not changed by Supreme Court. Maduran Kalu Patel versus State of Maharashtra AR 2002, 733. But Supreme Court itself is not bound to obey on decisions. It can change them, such as presidents have important place in decision making, but courts must apply them with due precautions. Lord Denning said that courts must use precedents creatively and not mechanically. The concept of precedents is given by British judicial system. Publication of law reports. The question is how the precedents get available. For this arrangement of publication of law reporting is done. Its history is very ancient. First time in 1774, along with the establishment of Supreme Court in Kolkata, the publication of law magazines started. Earlier, there was no such arrangement. In India, its publication was done at personal level. Both judges and advocates started this work. Their aim was to stop the situation of conflict between judicial decisions and make it homogeneous. Justice Francis McNaughton in 1824 described about judicial decision in his creation, Consideration upon Hindu Law. In 1825, Sir William McNaughton also described about certain judicial decisions in principle and precedents of Muhammad the law. In 1829, Longueville Clark included notes on cases in his creation, rule and order of the Supreme Court. Later in 1834, also publication of judicial decisions was done. Martin's report was published in 1841, which includes important judicial decisions of 1774 to 1871. Marley considered it very important. According to Marley, Martin's report is a work of the greatest utility and authority. Marley Digest 1. Later, many such reports published like Bignell's report 1832-31, Fulton report 1845, Montreal reports 1886, Bolmer's reports 1853-56, Gasper's commercial cases 1851 to 1860, George Taylor's reports 1847, Taylor's and Bell's reports 1847 to 1853, Marley's Digest of cases 1850. Southern Civil Court law reports. Southern Civil Court were courts of company and it was on top in Mofsisal judicial system. First time Southern Civil Court of Kolkata suggested to publish judicial decision. Law commissions also suggested to publish a digest of judicial decision. Consequently, by Sir William Hay McCartan decisions report was published of Southern Civil Court, Kolkata. This report was in 7 pages and it included decisions of 1791 to 1849. Later it was again published by the Act of 1843. Other civil courts were directed to record decisions in English and also directed to publish the decisions of Kolkata and Agra Other civil courts even every month. The publication of three reports were going on till end of courts in 1862. Time to time, decisions of Bombay Southern Civil Court was also published. In 1848, decisions of Bombay Southern Military Court were published from 1824 to 1846. Report of initial High Court. High courts were established. High courts were established in 1862. High Court published its own official report. Chennai High Court published its decisions from 1862 to 75 in 8 volumes. Later, such reports were published by Bombay or Kolkata High Court. 12 volumes of Bombay High Court from 1862 to 75, 15 volumes of Kolkata High Court from 1863 to 76 were published by name of Bengal Law Reports. During that period, various reports were published in different names. Weekly Reporter, Indian Jurist at Kolkata, Page Report, Marshall's Report, Cotton Report, Boyki Report, Madras Jurist at Madras, Hari Reports, Kindai and Hedson Reports, Sutherland Weekly Report, etc. Indian Law Reports Act 1875. Indian Law Reports Act was passed in 1875 to reform the level of publication of judicial decisions. At that time, Sir James F. Stephen was the law member of Indian government. In this act, many efforts were made to reform publication of reports. Its main object was to minimize the number of law reports and determined reports and to increase its quality. It is described in Section 3 of Act. No court shall be bound to hear, cited, or shall receive or treat as authority binding on it the report of any case decided by any of the said High Court on or after the said day, other than report published under the authority of the government, under the authority of the Governor General in Council. Official High Court reports after Indian Law Reports Act 1875. The publication of official series of reports became necessary. In this series in the Home House of Law Members Office. Indian law reports were published officially. The publication was under direction of state government. The publication of various decisions of various high courts was done by the title of ILR by following ways. Various publication started in 1876 of Bombay, Kolkata, Chennai, and Allahabad High Court. Two is Patna High Court in 1972. In 1926 of Lucknow, of Nagpur in 1936, of Punjab in 1948, of Karnataka and Assam in 1949, Rajasthan and Mysore 1951, Andhra Pradesh in 1954, Madhya Pradesh in 1957, Kerala in 1957, Gujarat in 1960, Delhi in 1968. Non-official report along with official report. Non-official reports also started published. Chennai Law Journal, MLJ, Indian Law Journal, Law Times, Allahabad Law Journals, All India Reporter, EIR, Kolkata Weekly Notes, Indian Cases, Kerala Time, Patna Law Times, Nagpur Law Journal, Chennai Weekly Notes, Labor and Industrial Cases, Income Tax Reports, Labor Appeal Cases, Company Cases, Sales Tax Cases, Election Law Reports, Rajasthan Law Times, Weekly Law Notes, Civil Decisions General, D&J. At present, among them, All India Reporter published from Nagpur is most famous. Privy Council Report. Privy Council was the topest appellate court of India before independence. The reports of Privy Council was considered most important. First time NAP published the decisions of Privy Council. They were again published in form of English reports. Later more published reports with the title More PC. Later the reports of Privy Council were published by the title More Indian Appeals MIA. The publication of appellate decision of Privy Council from 1872 to 1950 was published in 77 volumes. Federal Court Report. Federal Court was established for Indian under Indian Government Act 1935. Federal court decisions was published as federal court reports. Along with this publication of Federal Law General from 1937, Supreme Court report in 1950. After independence, Supreme Court placed the Federal Court. Decisions of Supreme Court are being published in various reports like All India Reporter AIR, All India Reporter, Chennai Law General MLJ, Supreme Court General SCJ, Supreme Court Cases SCC, Supreme Court Appeal SCA, Supreme Court Weekly Report SCWR, etc. Such the history of publication of law is very ancient. Publication of various magazines, journal and reports are being done from Southern civil courts to Supreme Court, but condition of publication is not satisfactory. In the opinion of Chief Justice R.S. Das of Supreme Court, the system of law reporting as it operates in India at present is neither efficient nor expedient. It is of the enforced, it is the enormous quantity but of uncertain and dubious quality. The system is inconvenient and expensive both for the litigants as well as the profession. It involves unnecessary waste of time and labor, and it makes the task of the legal practitioners difficult and confusing. It is clear that some reform are required in way of legal reporting. No matter the number of reports are less, but it must be qualitative. Dear friends, tomorrow we will study what do you understand by lecture method of teaching. Let us discuss the various causes of crimes. Discuss critically if crime is a product of slums, broken homes, and low intellectual level. What are the psychological causes of crimes? There is a reason behind almost every crime. We can also call it intention or motive. In criminology, the causes of crimes are different, which are based on some sect or ideology. Criminologists mainly consider following reasons for crimes: physical cause, family reason, social cause, commercial purpose, political reasons, psychological reasons, other reasons. One is physical cause. We can also call these personal reasons. The famous criminologist Lombroso is a strong supporter of this. Lombroso says that the physical and mental condition of criminal person is somewhat different from other normal people. This is hereditary. It was on this basis that Lombroso gave birth to the concept of congenital criminal. It was named atavism. Physical causes can be placed in the following subcategories: age, The first factor affecting the offences is the age of the offender. According to criminologists, person in the age group of 15 to 16 years commits simple offences, while person in the age group of 25 to 26 years commit crimes of serious nature. Sexual offences are more common in old age. Criminology Criminologist work is considered to be its supporter. Sex criminologists believe that men commit more crimes than women. According to Pollock, women commit more crimes like kidnapping, cheating, abortion, prostitution, homosexual intercourse is more common in men. Professor Smith also considers sexual perversion as a cause of crimes. Anatomy. The anatomy, shape, etc. of a person are also formed due to crimes. People of normal nature and mild nature commit less crime, whereas people of abnormal nature commit more crimes. Ugly, handicapped, dwarf people are considered to be hated and ridiculed in the society, due to which a sense of frustration arises in them and they start tending towards crime. Criminologist Goring is considered to be its spotter. Mental condition. The mental condition of a person also leads him towards crimes. The symptoms of a perverted mentality are retarded, psychotic, lunatic, inert, manic, perverted mind, etc. Such persons commit more crimes because they do not have the ability to understand the nature and consequences of the work. Jodard has proved by trial that criminals generally suffer from mental infirmity. They are also retarded. Goring has also tried to prove that criminals are of low intelligence by testing the intelligence of various criminals. In the view of criminologists, zero fellow criminals are of the psychological nature, and these tendencies are hereditary, which keeps on being transferred from generation to generation. Donald R. Taft, while stating the close relation between intelligence and criminality, has said that retarded persons are lazy and cowardly by nature. They do not even have the ability to think and understand, so they commit crimes without considering the nature and consequences. Such persons commit less sexual offenses because they lack sex. Sutherland is also the same opinion. Sutherland attaches more importance to the intensity of intelligence than to irrationality for the crime. He is of the opinion that some crimes require more intelligence, such as cheating, forgery, criminal conspiracy, etc. Such crimes can be committed only by planning and planning. On the basis of the above discussion, it can be said that crime is a result of low intellectual level. Family reasons. Family is another important cause of crimes. The conduct of a person depends more on family environment. The kind of environment a person gets in the family, he behaves in the same way. It has also been said that family is the first school of a person. Ronald R. Taft also says that the family is not only the first but also the most homogeneous, integrated and integrated and intimate social school. Mainly the following family circumstances are considered more responsible for crimes: lack of family control, disintegration of family, neglect of family, lack of companionship, emotional stress, etc. In a family where there are constant quarrels between husband and wife, the father is an alcoholic or gambler, the parents are an adulterer, the family is a drug addict, the financial condition is weak, the family does not have a religious environment, there is a lot of crowd, there are malpractices, there is a lack of mutual championships, the feeling of neglect lies, the marriage breaks up in the parent, there is a plethora of crimes in that family. In a family where there are no parents, there is generally a lack of discipline, and in the sense of discipline, the person becomes criminal. Where is it if the old bird dies? The eggs are adult. The eggs are adult. Similarly, the family which is financially weak, in which even the normal needs are not met, family members are unemployed. In such families, there are people who commit crimes like theft, prostitution, adultery. Suicide is also more common in such families. Unemployment is the main reason for suicide attempts. Maruti Shripati Dubbal versus State of Maharashtra 1987, CLJ 743, family disintegration is also one of the main reasons for crimes. Criminologist Toby believes that the disintegrated family has a more adverse effect on the children and young women, which increases the chances of them becoming criminals. Donald R. says that in most families, parents themselves push children to crime, such as asking children to steal call from the station. Similarly, members of the family with criminal conduct, behavior, and environment also start following the crimes. Sutherland is of the view that the children of such a family become criminals. A family whose environment is immoral, addictive, and criminal, in which there is absence of parents, one who is illiterate following malpractices, intensity, and disease, in which stepmotherly treatment of relatives, their expectation and jealousy, etc., is done, and which is very crowded in, whose economic condition is weak, and the family members are unemployed. Thus, family environment and circumstances are also important causes of crimes. Social reason. Society and social conditions are also a major reason for crimes. Man is a social animal. He spends his whole life living in the society. Therefore, the kind of environment he gets in the society, he becomes like that. In other words, it can be said that as is the society, so is the individual. The person of a civilized and cultured society is also civilized and cultured. If the background of the society is criminal, then its member will also be of criminal tendency. There are many such social systems and malpractices which led to crimes such as dowry system, child marriage, sati practice, death, feast, untouchability, etc. Dowry is considered to be the main social cause of crime today. Due to dowry, the crimes of dowry murder are increasing in the society. Newly married women are approached, treated with cruelty for demanding dowry. They are either killed or forced to commit suicide. Under unusual circumstances, it is crime of dowry murder. State of Karnataka versus MV Manjunath Gaudavaya 2003 SC 809. Society's practice of sati is also a crime. Omkar Singh versus State of Rajasthan 1988 Rajasthan Law Journal 1. Along with this, sometimes the stepmotherly and neglectful behavior of the society with the person also makes him a criminal. Many times a person is socially boycotted by the society on small things due to which frustration arises in the person and he starts taking steps towards crime. Economic cause, as it has been said about that, poverty, lack of economic inequality, etc. are important reasons for crime. When the family is in financial trouble, then the family starts turning towards crimes like theft, prostitution, adultery, unemployment, and unemployment are also the mother of many crimes and vices. The idle and unemployed person moves towards theft, loafing, prostitution, sexual exploitation, beggary, during drug addiction, etc. Greed, temptation, selfishness, and the desire to earn more money in humans also give rise to crimes. Theft, robbery, dacoity, criminal breach of trust, deceit, fraud, smuggling, black marketing, adulteration, bribery, etc. are the results of this longing. In the view of Aristotle, the desire for money and gold is the root cause of crimes. Most of the crimes are committed to get extra money or things, not just to meet the needs. Plato also considers temptation to be the main cause of crimes. A person commits many crimes by coming under temptation in the opinion of the Beccaria. Poverty, hunger, etc. cause despair in a person and he starts committing crimes. According to Donald R. Taft, the feeling of economic inferiority develops in a person when he does not get the money and the necessary things and he tries to eradicate the economic conditions through crimes. It is also true that class struggle is born out of economic inequalities and class struggle becomes the cause of many crimes. Political causes. There are also political reasons for crimes. Today it has become a common belief that most criminals get the patronage of politicians. Such persons commit crimes without hesitation and fearlessness because the government and administration cannot harm them. Politicians also have their own interest behind such patronage. At the same time, election, such criminals cooperate with politicians such as donation in election means to give financial support, to compel voters to vote by force and violence. Intimidation of voters, capturing votes, take away ballot boxes, bogus voting, etc. There is the reason why nowadays there is a talk of criminalization of politics. Psychological reasons. The psychological cause of crimes also plays an important role. This has been briefly highlighted in the subheading mental condition under the heading psychological causes above. Alfred Binet is a famous French Alfred Binet is a famous French psychologist. After continuous experiments in with psychological laboratory, he presented the concepts of mental age and intelligence in relation to the problem of retardation found in individuals and discussed its effect on criminality. American scientist Professor Alfred Binet carried forward the research by Professor German. In his opinion, mental age refers to that stage of the child when he has developed general intelligence and has the ability to understand the nature and consequences of work. This ability increases with age, which is called wisdom architect. There has been another scientist, Freud, who is considered to have made a special contribution in this direction, analyzing the tendency of criminality. He has said that there are always three major emotions in the human mind, which are called as follows: id, ego, superego. Id refers to the natural desires of human beings which arise out of their biological and material existence. For example, the affection of a person towards the members of the family arises out of the feelings of id. Ego refers to the human's awareness of one's own personality. For example, hunger, thirst, desire for sex are natural actions of human nature. Man wants to fulfill these desires only through legal means because he knows that the fulfillment of those illegal means can cause slander in the society and can hurt his ego. This awareness is known as ego, whereas the power of self-examination and restraint is called superego. People whose superego is strong, they can never commit crime because their superego always keeps them away from crime. The basis of this, Freud concluded that it responsible for the crime. The reason whose ego and superego are weak, they often commit crimes. To avoid crime, it is necessary to control it. For example, material desires, etc. Failure to do leads to despair, anger, or shock, which sometimes lead to suicide. According to Donald R. Taft, retardant people are generally lazy and timid in nature, so they are afraid of committing crimes, whereas intelligent people are not afraid of committing crimes because they know that they will never be caught. Such person commit crimes in a systematic manner. Dr. E.A. Houghton also conducted a psychological study of mentally deformed criminals. It was concluded by them that, according to almost all parameters, mentally deformed criminals are inferior to normal people. Such criminals should be kept away from the society, but Sutherland does not agree with this view. Psychologists also say that men are found to have more criminal tendencies than women. According to Sutherland, men commit more crimes than women because they have to maintain and provide protection to the family, while women have to play the role of ideal homemaker. Even in the family, girls are expected to be courteous, polite, and virtuous, while the boys are expected to be independent, not afraid of anyone, not suppress and always show masculinity. This education makes men criminals. The following reasons are also considered for psychological crimes: emotional instability, feeling of inferiority, and family environment. People with emotional instability are not able to take right and family and timely decisions, due to which they are prone to crimes. Similarly, a person with a feeling of inferiority loses his mental balance. They get affected by fear, anger, hatred, etc. If that becomes the reason to make them criminal, family disintegration and environment is also an important reason for crimes. Overall, in the view of psychologists, such persons commit more crimes who emotionally weak are financially poor and insecure, always fighting for livelihoods, idle and unemployed, suffers from family discord, disappointed in a love affair, becomes a victim of some untoward incident or frustrated since infancy. Other reasons, there are some other reasons for the offenses, such as: one is pornography, two is cinema, television, internet, and pornography film. Three is co-education, four is moral and character degradation, etc. Pornography has a bad effect on the mind of a person, and he soon turns towards crime. Arousing literature gives rise to sex crimes. The same situation is with porn families, porn films, and TV channels. To some extent, co-education can also be held responsible for crimes. Dear friends, tomorrow we will speak. There is no such thing as physical criminal type. Comment critically, also discuss briefly various psychological classifications of criminal, who is a criminal, how many kinds of criminals, and we will explain tomorrow.